important point to get makes sense. Don't worry, I'm not going to play this. I've done plenty of that. There's a quote. It goes, "Those who profess to favor freedom and yet depreciate agitation are people who want crops without plowing the ground, who want rain without thunder and lightning, who want the ocean without roar of its many waters." The struggle may be a moral one, or it may be a physical one, or it may be both, but it must be a struggle. Power sees nothing without demand. It never did, and it never will. Contrast that with the quote that you heard during this case. She spoke out, and now she doesn't want to suffer the consequences. That first quote was Frederick Douglass. The second one was Ed Bayron. They did not testify during this trial, but you heard a lot of his comments. And I think it sums up where this case fell at point. Where I told you at the outset, the question will get the ultimate underlying concept. And that is a question of how we treat those with missing power. This is not the case of the century, but it's a case in which the lives of many, many people were impacted by an event scheduled to last only 2 hours, and an incident that lasted first instance of charges that you are set to consider when you retire for deliberations, the last everything that's been discussed about this. The majority has been occurred in the span of about 30 minutes. It's all because some people were agitating, were dissenting, disrupting. Absolutely. It's undeniable. You saw it with your own eyes. There were disruptions, but they were brief. We've heard from multiple witnesses, those who readily acknowledged that they were speaking, that they were disrupting. They were doing so not to stop the meeting, not to prevent the legislators from being heard, but to allow their voices to be heard, because as many of these witnesses testified to you, they went there with an idea of what a town hall is. And I think it's an idea that is common. An idea that is pulled from common sense, normal understanding, right? A chance to actually engage, talk, to hear and be heard. That's not what's happening. And that frustration grew. They still didn't stop with you. Still didn't prevent it from proceeding. They still didn't stop these legislators from talking. And then they were singled out. They were told, shut the hell up or get the hell out. They were told, your voice is meaningless. They were told, these people, we got to get a little aggressive. That last one came right as Teresa was being pulled from her seat. Violently, roughly. And I would ask The outset, as you start your deliberations when you retire, contrast what you saw to some of the statements that you heard. Two witnesses in particular, both of whom claimed that what you saw was really actually intended to protect both Sheriff Morris and the defendant tried to tell you that their treatment was actually for their own good. They were just trying to handle her with as minimal of force as possible. Ladies and gentlemen, you watched lots of videos, and like I said, I'm not going to play them back for you. I think your recollection, and you'll have the opportunity to play them again. I don't know if you'll need to make clear that that was not the case. There was no care for Tracy Morris when she was drugged out of that town hall unceremoniously. Her shirt was allowed to lift up, her body exposed. She told you, it's humiliating. We can all understand, we can all relate to that. Of course it's humiliating. She talked about how it felt. She talked about the result. You heard that echo from this line of victims that the defendant caused, that he facilitated, that he participated in. And what's most important in all this is this instruction talking about he was commanded by the sheriff. The word right there is probably the most important word when it comes to that instruction, whether there is an affirmative defense available to this defendant in this case. He was commanded by the sheriff to aid him in the execution of his duties as authorized duties. That's another very important point. But you don't even need to get to the authorized part. You don't find that he was commanded to do a single thing, because that is what the evidence shows. Not a single instance was the defendant commanded to do anything. Now he wants you to believe, or he testified, and you'll probably be told that that finger point, that's not command, ladies and gentlemen. One of the things you get to use in deciding this case is your common sense and your reasonable inferences. We talked a little bit about that. We all agreed that that was appropriate, that you were willing to do that. And I'm asking you to. I'm asking you, I think you'll a lot of what this case is, and a lot of the decisions you have to make before you will be resolved by simple application of common sense. Like what you've seen, the documents you've been presented with, the totality of this case, like modicum common sense. You'll know. Sheriff pointing to the defendant, pointing to the individual. It could have been anything it had not. Maybe you look with the eyes. That he's trying to, the assertion here, and I think you can reject it as absurd if you find that it is absurd. I would posit that it is, that constitutes a command. That was where this incident began. The moment Ben Stallings, and again, rely on your recollection of the evidence and what was actually introduced, what the actual evidence shows, what he actually testified to, what any credible evidence shows, with the recordings that you'll have back with you of the time in which he was taken out, that have audio. Listen closely, you will not hear the plain words that Ben Stallings said. But even if you did, that is not a crime. It's not a crime to shout an expletive, even in an event like that, a public. It is not a crime. You heard Ben testify, that's literally all he said, and the sheriff decided to remove it. And then, that's a command. You don't have to believe it. And that theme remains throughout all of these charges. Ben was not commanded to do a thing with Teresa Moore. And yet he jumped in, and you watched him on video as he joined the two individuals, probably the only two that might possibly be able to have made any claim to the affirmative defense that you have the instructions. There will be argument. He was not present, and yet he joined. They stopped because he saw the sheriff removing Gregory Johnson simply for stepping forward and saying, "Hey, leave her alone." Importantly, he did not interject himself. He did not. You can see with your own eyes what he did, what he clearly did not do. What he clearly did not do was get in the sheriff's way, not body to the sheriff. He did not. He simply said, he spoke up for this woman that was being attacked, unidentified individuals. And he said, "Leave her." We were told by the sheriff of this county that is encouraging Teresa to resist. That's absurd. But also, so what? She had a right to resist. She didn't know who these men were. There had been no basis to it. Not even the sheriff had followed any modicum of proper police procedure. He hadn't told her what she'd done wrong. He tried no de-escalation tactics. He simply walked up to her and said, "You're out. Get up now, or be escorted out." She responds with a question, "Escorted out?" And then he just starts going, yanking on her, pulling on her. No explanation for why, no warnings given, no request, "Hey man, we really need you to to stop shouting, we really need you to be quiet, otherwise we are going to have to ask you to leave." Nothing. None of the evidence shows it. Gregory interjects. "Hey, leave her alone," and then he is roughly pushed out of that event, simply for saying, "Hey, leave her alone." That is also not crime. Certainly not interfering with anything, any lawful conduct. When the defense saw this, again, not a single piece of video, audio, evidence, submitted documents, anything supports that he was commanded to do anything. He told you actually why he did it. He's assumed. Search your jury instructions, ladies and gentlemen. You will not find any relief of liability or assuming that he could help out. And you imagine the chaos if citizens were able to just assume that they could jump in and do whatever they wanted to aid law enforcement. That's not how law works. And that's certainly not what your instructions. And then went out into the hallway. Is Gregory, who testified to you about his pre-op knee surgery, had the noticeable, I think even still as he's walked up to the witness stand, was still limping. Told them, "Hey, watch the leg. Watch the leg." He watched on videos, roughly picked his legs up. He wasn't resisting. He wasn't pulling away. He wasn't doing anything. They were still, I think his statement, Gregory was kind of a wild one, let's just say that. His statement, what are the statements? "You would think that I was a 23-year-old drunk at the beach." This is how he summed up how he was treated. Quite frankly, I have to agree. But he wasn't a 23-year-old drunk. He was a guy who was there on assignment by his wife to find out about school bond issues, funding, boring stuff. And he complied initially when he was asked, not demanded, just asked. "Please get up." Okay. Not entirely knowing what's about to happen. And then when it does start happening, he speaks up. And then he suffered the consequences. Consequences that were not based in law. Consequences for which you will find absolutely no justification in the instructions that you make. And then there's Sarah. Sarah, similar to Greg, nothing more. She was actually right. She was on her way out. When she saw how these men were continuing to treat Teresa out into the hallway, the rough treatment of this single woman, she said, leave her alone. Let her go. And then the defendant turned his ire towards her and attacked her. I don't know how else to describe it. I think it aptly sums up what you witnessed on that day. Because all these descriptions of why she was treated that way, they fall flat when you watch that video. I encourage you to watch it. Even without the sound, videos from the hallway of that school tell a resounding story. They speak louder than even some of the videos with them. And they depict the defendant battered Sarah Forsberg violently for doing nothing more than standing at the side of the hallway saying, hey, leave her alone. That's a bird's eye view. I'm going to run through really quickly some of the elements that you have. It's kind of the boring technical nitty-gritty stuff, but it's really important. So when deliberating, there's a couple of key instructions that you need to pay attention to. I'm going to run through the charging instructions in a moment, but first, for all of these offenses, there are common elements, right? So charging instructions, those are the ones. Say it's for battery, it's instructions 13 through 16. For false imprisonment, it's instructions 20, 21. And then for the city code violations, it's 24 and 25. I'll be real candid with you, ladies and gentlemen. It seems like there's probably not much of a dispute at all as to the violations in 24 and 25, or at least not a real dispute based on what you heard from the defendant testify and the evidence that was presented to you beforehand regarding his violation of very simple Coeur d'Alene City codes. You're going to have a copy of the Coeur d'Alene City Code that he violated back with you in the jury room. That's a certified copy of that document. States Exhibit 9. I will try my darndest to keep these in order. That spells out very simply. And I went through it with the defendant, what he had to comply with as the business owner, as he testified to you that he had started this business back in 2012. That's my record. Quite some time. More than a decade. He's been running a security business. And I think it was reasonable. It was reasonable to assume that he would be aware of the requirements for him to operate that business lawfully within the city of Coeur d'Alene. He confirmed he was aware of the uniform code. It does require that they have those words emblazoned on the front and on the back security. You saw with your own eyes that wasn't there. It required that they have an executed contract, or if they're going to act on behalf of a third party, that they have a contract. The evidence was indisputable that none of these men had an executed contract. And why do we know that? Because we have the unexecuted contract. The tribe acknowledged to throw together and send to members of the KCRTC to be executed. And you heard confirmation there was never an executed contract returned. The defendant separated from that. So just as a matter of impossibility, none of them could be carrying a contract that authorized them to act on behalf of a third party. But nevertheless, they were. They clearly were trying. They were purported. So I posit to you that those two offenses are quite clearly established beyond a reasonable doubt. And I'm going to run through the common elements that those share with the others, and then just highlight some of the pieces of evidence that establish the main elements for 4 counts of battery, 2 counts of false imprisonment. So the common elements that I think are established for all of them, and I would propose are not really any kind of reasonable dispute. I have absolutely no doubt the counsel will correct me if I'm wrong on that. And that is, first and foremost, the when. On or about February 22nd, 2025. That's not any real dispute. In fact, I mean, you get an exhibit that tells you when this event occurred, February 1213. Where contained on there as well, Coeur d'Alene High School in the city of Coeur d'Alene, Steuben County, State of Idaho. Not real dispute. So that's first and second elements. The who. Defendant sitting before you, he testified, he self-identified as Paul Trouette. There was multiple, well, all of the witnesses, or at least the victims, all identified him as Paul Trouette, as the person that engaged in unlawful conduct that's alleged for you to consider. So that's not any meaningful dispute. So we got a couple of quirks to work out with this one. There's an additional angle for you to consider with these charges. That is the concept of aiding and abetting. Now, what sets that out? Where should you go if you're at the question, well, how does this aiding and abetting work? During instructions of record. Well, that spells out what kind of conduct the defendant should engage in in support of the other individuals. You've heard their names, you've heard them identified in several witnesses and in several exhibits as the individuals involved, the employees of the defendant. And that was Jesse Jones, Christopher Berg, Russell Dune, and Alex Trouette. And so through various of these charges, it's asserted that he aided and abetted these individuals in doing some of these things, which means, and I think probably the prime example of this, ladies and gentlemen, is the charge for bed stallings, the battery charge. Because I think it acknowledged at the beginning, in the opening, that his was, as far as the defendant's physical contact with Mr. Stallings, was rather slight. And I think you saw in the video, and I think it's the East Hall video, State's Exhibit 20 or 30. That as far as the defendant's conduct, he puts his hand on his back, he kind of turns him towards the exit, rather gently ushers him out. Now granted, you could go to your definition of battery. Battery doesn't require force. Force is one way. Force or violence, right? And then there's unlawful, unconsented touching. So if you touch this person, then it's wrong. And that's what he does. Without any lawful basis, they were out in the hallway, he was already leaving, there was no reason to put hands on this guy. Ignoring the actions of the other individual involved, even then, it's a battery. But then you have the conduct of Russell Dune. Now remember, Russell Dune is a subordinate of the defendant. He acknowledged that. Russell Dune is his employee. Russell Dune was someone he was supervising in this context, and so when Russell Dune decided to needlessly push Ben Stallings when Ben Stallings stopped simply to wait for his visually impaired wife, that conduct flows directly to this defendant. And that's what this instruction is saying. Aiding and abetting. And when you have a question of how do I apply what does affirmative defense, does that apply to Mr. Dunn in this context? Well, the answer is it's yes, and that it's no. It's yes in that if he acted at the command of the sheriff, you have evidence that indicates that, then yes, it would then just be left to the defendant, because we know that's not a command. Or recall that that's the only thing, it's the only thing you have any evidence it was done at all for Ben Stallings' removal by the defendant and his subordinate, Mr. Dune. There is nothing, no evidence before you whatsoever that Mr. Dune was even given the hand signal. Certainly no command, but not even given the hand signal. And so that's how this aiding and abetting concept applies. It will apply, you'll see at each of the charging instructions, it will identify the persons that the defendant is alleged to have aided and abetted, if not personally doing the conduct himself. And like I said, I think Ben Stallings is really the only one where that is going to be most active. And so, running through then some of the disputed elements, we've already talked about a few of these, but I'm trying to be quick, I'm trying to be conscientious of your time when it's wrapped up so that you can start deliberating. Because I want you to review the evidence. I want you to look at any of these videos that you are concerned about, and you've forgotten, you're like, I'm a little fuzzy on that, please review. Because I want you to know I'm not shying away from this burden beyond reasonable doubt. Ladies and gentlemen, I think we have that ample amount. Every single charge. Here's what I think you have to consider in that regard. We talked about the installments. I think that evidence is quite clear. Although he didn't have any marks, he didn't testify about having any red marks, anything like that. But that was an unconsented to touching, and the conduct by Mr. Dillon was force or violence. It was a bit of a hand fight there. And Stallings was justified in resisting that, in pushing his hands away and saying, stop touching me. There's no basis. There's no reason. Just no reason. Teresa Oracle, you heard a lot of evidence about Teresa. And again, in all of these instances, we have a wealth of video evidence to go back and review, pinpoint for each of these individuals what conduct happened to them. What you know with Teresa Oracle, from the very first video that we showed you, Jesse Jones' cell phone video that was 6627, was that she testified, she told you. Yet when the sheriff tried to tell her that she had to leave, she first didn't initially recognize him as the sheriff, and then didn't recognize what, if any, authority he had to tell her to leave a public setting, a public town hall meeting that was not being put on by the sheriff's office, and not in the reserve, it was not on the sheriff's office property. There's no clear articulation of what authority do you have to make me leave. She hadn't been asked to leave by the MC. That was clear. That is clear. Not one point, not once during that meeting did the MC say, hey, security, could you remove that lady? Not once did he say, ma'am, we need you to be quiet. Not once was any of the individuals targeted because they spoke out and afforded any such opportunity. Opinion all the way to Ben Stallings, who was shouted something. It wasn't an expletive. I believe his testimony and the audio will confirm is, are you a doctor? That's what he said. That's what was so onerous, what was elevating, I think was the term. Something along these lines. I'm paraphrasing here some of the testimony because it's been a long day. Was causing the tenor of the meeting to deteriorate by saying, are you a doctor? It's not illegal. There's no basis to be illegal. Teresa testified to you about her understanding. She thought she was okay to do the same, but that clearly ultimately ended up not being the case because little pieces of evidence you saw throughout this trial being clear. Her removal from that meeting was almost pretty tough. We saw the moment she arrived, one of the cameras, that crowd-facing camera. A minute later, is adjusted. And this adjustment is precisely to bring her within frame. Why? You know why. The sheriff testified about who Teresa was. She testified about their not exactly cordial goings on. No one else during that entire meeting was singled out for anything that would remotely relate to she was. Gregory Johnson, you have the very clear, positive, almost indisputable video evidence of what he did and what he did not do. As I said, it was our board to leave her alone, and then he was roughly ushered out by the sheriff, no command to the defendant, and yet the defendant joined. The defendant then suggested placing him in zip cuffs, asked the sheriff. The sheriff did not say he needs to be placed in zip cuffs because I don't have cuffs. The defendant asked him, do you have cuffs? I have zip cuffs. The sheriff says, no, I don't have cuffs. Okay, I'll get zip cuffs. Never. Listen, Jesse Jones' video is your key for that one. Listen to what's said there. Because the video itself, it's what you would expect from a cell phone video. It's sort of roughly taking somebody out. It's a whole lot of frame of the jacket and the back of Greg's head. Not once is there a single command for him to do anything. Certainly not put Greg in zip cuffs. Certainly not hold him there. Certainly not pass him off to one of his subordinates, Jesse Jones, and hold him there for an additional 20+ minutes. Or even held there after law enforcement as they tried to sort out this. that time, as the video shows, he was patient. He was compliant. He had done nothing. And then Sarah Ford was written. And again, your hallway videos, your best evidence on that. There's two angles. There's the angle facing away from the door. There's the angle facing towards the door. And they both show the identical thing, which is the defendant's testimony that he was just behind her and never contacted her any other way. The testimony was that, whether intentional or not, that's not really the assertion. The assertion is that he intentionally was touching her in that fray, touched her. And you saw on her face the emotion, having to recount that in front of you. I say that, not to evoke sympathy, but because that shows credibility. I'm going to talk about that now. Because in all those, go through those batteries, and then the false imprisonment, I'll run through those really quickly, and then we'll talk a little bit about some of the evidence now. False imprisonment of Teresa began almost from the outset. The defendant participated in that both directly and by aiding and abetting. Now remember, the only testimony you heard, going back to that affirmative defense, the only testimony, the only evidence that you have of anything that could approach, command the sheriff, any of these individuals, was right at the outset, Christopher Berg and Jesse Jones. Those are the two gentlemen, two unidentified men. He said, these two, they're out. That was more intense than her testimony. We saw her video confirming all of these things, confirming the interaction. Had with the sheriff confirming his inexplicable decision to tell her that she also had to leave when she did nothing. Quite nothing. On that same point, you saw a couple other times in the video evidence. Watch for this while you're reviewing the sheriff. Just kind of doing, there's that Oprah thing where she's like, you get a car, you get a car. It was like the sheriff was, you're out, you're out, you're out. There's a lady you'll see, she testified, she's in pain. He just said, you're out too. And she goes, me? Why? I think that kind of aptly encapsulates how the sheriff is approaching this whole thing. Just, I'm the sheriff, therefore I get to kick you out of this event just because. Because I'm the sheriff. Because but the event seems to be getting a little out of hand, so he just started kicking people out left and right. That's not how the law works, ladies and gentlemen. It certainly wasn't any command. Certainly not a lawful command. So let's talk, and then, just to finish up, close out the false imprisonment side. We saw what was happening to Teresa. We saw the attempt to place her in zip cuffs out in the hallway. We saw how she was continuing to be held down in the hallway, even though she was now outside the event. So any rational idea of why she needed to be removed was done. They didn't take her to the side hallway. They didn't take her to the non-public exit. No, it was right in the middle of the main exit where everybody was coming and going. And they held her there. And they tried to place her in zip cuffs. They restrained her liberty. They prevented her from going where she wanted to go. They did the same thing to Greg Johnson. Before that, they held him in the hallway. They restrained his liberty. They prevented him from being able to come and go where he wanted. There's no lawful basis for him. So you heard from those witnesses. There's multiple witnesses. Ben Stallings, Teresa Bornville. You heard from some foundation witnesses at the beginning. Kelly Human, custodian, talking about how she found the document. That was primarily to get that foundation so that we can get that security advance before you, because I think it's a pretty important piece of information for you to have. It makes it quite clear the roles the defendant had in relation to these other defendants, or to these other individuals that he was supervising that were his employees. Michelle talked about the walkthrough that was done. I was concerned this individual had no idea who he was, making these questions, seeming to scout out the place. Why she informed SR Renault about what was happening, SR Renault's conversation with the defendant, and the stuff about the firearms, that statute, is kind of beside the point. The point of that was more to establish that there was not a contract. And again, you have the unsigned contract to make that abundantly clear, but just to clarify, that hadn't actually been contemplated beforehand. But even though he's supposed to be an experienced security agency owner, he didn't take some basic steps that would be required for him to legally engage in the business, his business, using his business of providing. And then you heard from Mark Stewart, one of the internal folks with KCRCC, who planned this event, about how he reserved it, what his understanding, his expectation was, the process of reserving that. You'll have that document, the facility use agreement, which notably during the questioning, there was mention of the case by the sheriff. There's a contrast between what was going on in that case and what you have, which is you have a facility use agreement. This is not a lease agreement, ladies and gentlemen. There's nothing even remotely close to it. This is not giving people the same, KCRCC, the same rights and the authority that they would have if they actually executed a lease agreement, if they were a tenant. They reserved the space for 2 hours. Maybe a little bit more. They reserved the space, that's it. School district still own that property. School district still retained all rights to that property. School district retained the ability to exclude someone from the entire property itself. And you heard no evidence that they authorized any of what you saw. And if you have a question again about all the nitty-gritties in school policies, you'll have copies of them. These are public documents you can download from the school district website at time. Importantly, 4140. Basically, it's the principal or his designee. You heard a lot of testimony about that. SRO Renault, who can kick somebody off the school property. There's a line of succession. And even he acknowledged, like, if the principal is present, he actually can't kick anybody off the property as the school resource officer. And so what thought is there that this group that just reserves this event, this space for limited time, will be able to do so? The final points, ladies and gentlemen, again, I'm respectful of your time, and I trust your common sense in reviewing it. You've watched a lot, you've been very patient, you've understood, I'm confident you'll be able to understand what you're being instructed to do, the tasks that you have before you. The final point that I want to make is on this idea of beyond a reasonable doubt. That's the state's burden. Again, the state embraces that. It's when we take it upon ourselves to ensure that we don't convict innocent. But remember, it is not required to prove beyond all doubt. Though, in this case, quite a bit of video evidence might make that kind of beside the point. But ultimately, it's beyond a reasonable doubt. So if your doubt is one of speculation, if it's one of, yeah, well, maybe could have, would have, possibly, maybe somewhere, that somehow was not captured on all of this video evidence, on all of this witness testimony, somehow maybe there was actually a command made to this defendant specifically, not a general command, not a finger point, not a nod, nothing of that nature. It has to be a command. You know what a command is. It's like, man, my kids, take the garbage out. If I pointed them and I pointed the door, they're going to laugh at me. That's not. That's what's wrong. But before you can get to that, find if there's proof beyond reasonable doubt of all these other elements. I posit to you that there is. Review the evidence and you can find that it is substantial to the point of being beyond any reasonable doubt. And ask yourself when you retire, keep in mind what we talked about at the beginning. Keep in mind what we started this case talking about, which is how do you treat those people that disagree? What kind of message do you have sent? This is the conduct that takes place. The meeting that's supposed to be a public place, public officials, reportedly to have our voices heard. Will you allow the defendant's conduct with regard to these victims to stand despite no lawful basis? Or will you do the evidence points to. When your reasonable inferences, your common sense tells you is the right decision. I ask that you review this evidence, take the time that you need to make sure that your decision is confident, that it's beyond reasonable doubt. Find the defendant guilty of all 8 counts. Thank you.
Closing remarks from the defense.